the Legal Corner podcast series. Welcome to today's episode of The Legal Corner, a podcast which covers a variety of legal issues to keep you informed. Hosted by attorney at law Colin Dinoon and communications specialist Leonardo Torres. Thank you for joining us for another episode of the Legal Corner podcast series. It's such a pleasure to have you as we continue along season 3 with more interesting conversations and topics to the benefit of you, our listeners. And today's episode is no different. In season 2, we touched on a little bit of real estate when we had Gerald Andrews on our program. And today, for some of us who cannot yet own our own property and rent, this topic is really just for you because it speaks to the relationship between landlords and tenants, and that is the topic of today's episode. Now, I'm so happy to introduce our guest. His name is Mr. Aaron Mahabir. And just to tell you a bit about who he is, he was admitted to the Trinidad and Tobago Bar in November 2018, and since then has been a member of the Veritas Chambers in Port of Spain, Trinidad. He has appeared as an advocate as well as an instructing attorney in Magistrates Court, the High Court, the Court of Appeal, and the Judicial Committee of the Privy Council. He is also an associate of the Chartered Institute of Arbitrators. His areas of practice include criminal and civil litigation, family practice and procedure, and public law litigation. Mr. Mahabir has a particular interest in migrant issues and regularly assists in pro bono cases involving migrants and refugees. He is a junior ordinary member of the Council of the Law Association of Trinidad and Tobago and a member of its Human Rights Committee and Legislative Review Committee. He also has an interest in other human rights issues and has appeared for the Law Association in the case of Akile Chambers versus Attorney General of Trinidad and Tobago 2022, which dealt with the right of murder accused to make an application for bail. So this is someone you all may have encountered in reading, whether it is your daily newspaper or whatever they publish online. So we're very happy to have him as a guest. Aaron Mahabir, how are you doing today?
I am doing quite well. Thank you very much.
It's such a pleasure to have you. So let's get right into today's episode. So as I mentioned before, a lot of us don't have that privilege of owning our own home. We rent. So there would become that situation of a landlord and tenant situation. And today's topic, I think it's very important, as many of us can pull from the information that we would be bringing forward in today's episode. So first, let's start off with an easy question, at least for you. Who is a landlord?
It's a very simple concept, and indeed, a landlord is a person or an entity, because companies can also become landlord, who owns real property meaning land or building and land, and then leases it out to a tenant. A tenant can also be a company as well, in return for rental payment.
All right. Now, in simple terms, can you just break down the difference for us between a tenant and a leasee?
A tenant is someone who occupies property under a tenancy agreement. Tenants are allowed to have exclusive possession of the property in exchange for rent paid. What this means is that the tenants are able to refuse entry to anyone, admit entry to anyone, including the landlord in certain circumstances, whereas the licensee is someone who is occupying a property with permission and does not pay any rent whatsoever and does not enjoy that exclusive possession concept of admitting and allowing persons to come in. And he cannot prevent someone from coming in as well.
All right. Now, can you tell us what are the elements of a valid lease? So most of us who rent, usually we would have to sign a lease, whether it's for a year, 6 months, or month-to-month lease. Tell us, what are the elements of a valid lease?
Well, there are really three elements of a valid lease. Firstly, the lease must provide for exclusive possession. As I indicated previously, exclusive possession is the right to allow persons to enter and to prevent persons from entering. If you do not have that power, it is not a lease. Secondly, there must be consideration in the form of a premium or periodic rents. So every month you pay rent, or every year you pay rent. Once there is that rental clause, then it can be considered to be a lease as well. And the last and final element is that there must be, or it must be for a fixed term or a periodic term. I may either expressly say 1 month, 3 months, 1 year, or it might infer to be 1 month, 3 months, or 1 year, depending on how you pay the rental of the property. So, unless these three features are present, and all three must be present, it will not be a valid lease. Now, in Trinidad and Tobago, if it is a lease is more than 3 years, we have an additional requirement to have that lease done by way of a deed and registered in the Register of Deeds at the Registrar General's office. Failure to register the deed or failure to do the lease by deed will result in it becoming a periodic tenancy. So it will, instead of being a fixed term for, like, say, 4 years, it will be a monthly tenancy if the rent is going to be paid on a month-to-month basis.
All right, thank you for that information. Now, tell us, what is a statutory tenant?
A statutory tenant is really someone who enjoys a statutory lease. What had happened in Trinidad and Tobago is that the government will have passed the Land Tenant Security of Tenure Act. And what that act did is that any tenancy existing before 1981, whether it be a monthly tenancy, a yearly tenancy, it was converted automatically to a 30-year lease. What that meant is that persons who had a lease, whether it be monthly or yearly, prior to 1981 and even up until 1981, got a 30-year lease for the period of 1981 to 2011. And at the expiration of this lease, being 2011, the tenant, which is its statutory tenant, he had the option to renew for a further 30 years, or he can purchase the land alone at 50% of the open market value without the cost of the house being factored into it. So, in a nutshell, a statutory tenant is someone who enjoys that statutory lease as provided for in the Act.
Okay, perfect. Thank you for that explanation. Now, folks, we're going to take a quick break. And when we come back, we're going to get into some of the topical issues regarding landlord and tenants. And I'm sure some of you are looking forward to this next segment because this is where things get a bit dicey with this kind of relationship. So stay with us. We'll be right back. All right. Thank you for staying with us here at the Legal Corner podcast series. So today's episode, as I mentioned before, is the relationship between landlords and tenants. So before the break, we got into some of the simple terms. You just get an explanation out of the way with what is landlord, tenants, lease, what makes it valid and whatnot. So now we're going to get into some of the issues that could arise out of this relationship that I'm sure many of you really want to know about, as maybe some of you all may have experienced or know someone who have experienced. So maybe when you're ready to rent somewhere, just with that added knowledge, you know how to operate as a tenant. So tell us, what situation rather give rise to disputes between landlords and tenants?
Well, the situations are quite numerous. So what I will do is that I will address them on the landlord side first and then on the tenant side. So on the
Sure.
landlord's so on the landlord side, the main dispute is really the non-payment of rent. In the leases or the tenancy, it would specify in the lease how much your rent is, when it is to be paid, and in what method it should be paid in. And most of the times, the tenants do not comply with that uh, covenant or that clause in the lease, which results in a dispute. Other disputes can arise on the landlord side with respect to property damage as a result of willful neglect. For example, if it is that the tenant does not take care of the surrounding areas, clearing the drains, cutting the grass. There may also be disputes regarding pets. Some covenants would be you're not supposed to have a dog, a cat, or any sort of domestic animals on the premises. In those circumstances, dispute arises. There may be dispute in relation to the particular purpose in which the tenancy exists. For example, a landlord may rent to a tenant to be used for residential purposes, and yet the tenant decides to open up a mini mart in the premises that is for commercial. So that might cause a dispute. And there's also the most common dispute of subletting, meaning you're renting out the property or you're inviting other persons to stay in the property who is not the tenant, who are not the tenant. That causes other disputes. There are instances where a residential dwelling are used for a brothel purpose. That causes a dispute as well. And even if it is the tenant makes structural changes to the premises. For example, if the tenant decides to break down a partition and wall because he wanted more space, even though he is renting both rooms, he wanted more space, that will cause a dispute because that is not how the tenant got the property. So these are just some examples of disputes. And as I said, the disputes are really numerous and it's a fact specific. Uh, it's really fact specific. Now, with respect to the tenant dispute originates from his use and enjoyment of the property. If it is that the landlord keeps coming and knocking on the door every single month, the landlord ought not to do that because the tenant has a right to quiet enjoyment. The landlord ought not to demand, open this door now and give me access without giving formal notice that he intends to inspect the premises. The landlord must also not do any act to make the property less fit for what it is. In other words, if it is the property is for a dwelling purpose and the landlord decides to erect a big wall that stops the wind from blowing into the premises, that is going to affect the purpose in which it was given because then you do not have any natural air coming into the premises. There's also the third dispute that can arise, which is if it is the landlord does something or fails to do something to make the premises fit for human habitation. In other words, if it is that the landlord fails to clean the soak away or the suspect, or fails to, or let's say, erect something, a wall, for example, again, to stop natural lighting, ventilation, or fails to make any sort of repairs, big, large scale repairs, such as repairing the roof or repairing a wall that may be fallen down. These are instances where a dispute can arise on the part of the tenant, and the tenant has a right to tell the landlord, listen, you need to fix the roof. Listen, please clean the suspect. But when it comes to minor stuff, for example, changing the light bulb or maybe just cleaning the drain, that is something that the tenant must do, and the tenant cannot demand the landlord to do that because the tenant has an obligation to keep the property in what we call tenant like state.
Okay, we understand that. Now, staying on the topic of the situations that can give rise to disputes between landlords and tenants. Let us first talk about landlords. So let's say an issue has arisen. How can a landlord recover possession of their property?
Well, before the landlord can even get to that stage, the landlord must first ensure that the tenancy has come to an end. So if the tenancy is not at an end, he must serve a notice to quit. He can't just waltz in today and say for today until the tenant get out. If it's a monthly tenancy, he must serve a notice to quit, given 1 month's notice to vacate. If it is a yearly tenancy, he must give 6 months' notice to quit. And if the tenancy is at an end, at that point in time, and the tenant still remains in occupation of the property, he can do he can file ejectment proceedings in the magistrate's court, depending on the value of the rent, or he can initiate proceedings in the High Court for a claim in trespass and recovery of land. He cannot hire a bailiff to act on his behalf to evict a tenant without a court order. Neither can police officers come, or he cannot even employ police officers to intimidate someone to leave the premises. He must, before it is he can hire the services of a bailiff or police officers, he must have a court order. And in the absence of a court order, the only thing he can do is file the proceedings to get the court order.
Right. Thank you so much for clearing that up for us, because we have heard of situations where the bailiff or the police officer would just arrive at the person's apartment that they have been renting for some time, and there becomes a bit of a showdown at that point. So thanks for clearing that up with us, whereby we need to know that the landlord rather needs to know that they have to make that application through the court, and it's not just a police officer or a bailiff coming to the premises. Now, let's talk about the tenant now. What rights does a tenant have under a month-to-month lease? And we'll get to the other types, but just let's deal with a month-to-month lease for now.
What the tenant, the only or the primary right of the tenant at a month-to-month tenancy is that of exclusive possession and quiet enjoyment of the property. What the tenant can be secure with is that the landlord cannot just waltz in his property. If it is he is renting a property from the landlord for a month-to-month tenancy, then at each month he is entitled to treat that property as his own. He's entitled to invite whoever he wants into the property without the landlord saying, I don't like that character. He's entitled to tell someone, if the landlord brings, let's say, a friend into the property, he can tell the friend of the landlord, no, I don't want that person in my premises or in my apartment. So he's entitled to this thing we call exclusive possession. He's also entitled to quiet enjoyment of the property. So the landlord cannot take off the electricity. The landlord cannot cut off the water. Once he has a month-to-month tenancy, he's entitled to enjoy the property for the duration of the month to the best of his ability, and he's entitled to enjoy it without any sort of disruption or interference from the landlord. The tenant also has a right at the end of the month-to-month tenancy to get back his security deposit in full, provided that there are no deductions made with respect to the repairs at the end of the tenancy arrangement.
Now, I'm happy that you touched on the security deposit, and I will touch on that question right after the next one I'm going to ask, right? So, my next question is, what remedies are available to a tenant who has been unfairly treated by a landlord?
Just as the landlord can terminate the lease, a tenant also has a right to terminate the lease by giving notice and outlining the breach or the default on the part of the landlord. And the tenant can also sue for damages in contract. If there is no written contract, he can still sue on the implied guarantees provided for under the legislation and the common law. But before we even get to that stage, he must make sure that the lease has been terminated. Now, if it is he does not wish to terminate the lease, he can still call upon the landlord in accordance with the covenants and in accordance with the implied guarantees provided for in the legislation to rectify the issues. For example, if it is that the landlord failed to clean the cesspit, he doesn't, and he wants to remain in the property, he doesn't necessarily have to terminate the lease. He's entitled to, by serving a notice or a letter, call upon the landlord to do what is required of the landlord. And it will be incumbent on the landlord to act on it, because if it is he does not act on it, it affects the damages quantification if the matter goes anywhere. For example, if a court action is filed.
All right. So before we wrap up, let me ask a question. So we have a situation whereby a landlord and a tenant has an arrangement. They have a lease going on. They paid their deposit. The lease is now expired, and now it's time to move out. So no problem so far. They packed up their stuff. They find another apartment, as the case might be. Now, the landlord is making frivolous claims against the tenant as it pertains to damages rather that would have been incurred at the apartment. Now, in that situation, what would you advise a tenant to do in that situation where they have not received their deposit? Their deposit rather was not returned to them.
Well, in those circumstances, this is why it's important before a tenant gets into possession of a rented premises to do an inventory or a stock count or take note of where are the various flaws or the defects so that at the expiration you have something to compare it with. Because when it is the landlord, when it is the tenant leaves the premises, he needs to leave it in the same state he got it in. Now, if it is that exercise was not conducted, then what the tenant ought to do is to demand from the landlord what exactly is the defect, what is the cause of the defect, and give the tenant the opportunity to explain. Now, if the tenant is coming to say that that was always there, one will hope that the tenant will have some sort of documentation to say that he made a report if that happened during the dependency of the lease, or he will have identified it when it is he came to inspect the premises at the start of the lease. If he has neither, then it would really be a situation of a he say versus she say, and who is more credible in that regard.
All right. So our final question before we go. So you mentioned in your response that they should um, return the apartment in the condition that they received it when the tenancy began. Now, there is something in law that I've heard about that pertains to fair wear and tear. Can you tell us just briefly what are the limitations of that, what it can and cannot cover, and you could probably keep it within the realm of the deposit being withheld because of those issues, and just general information so our listeners can get an appreciation of what they are entitled to when their tenancy has come to an end.
Well, fair wear and tear would be usual usual defects or usual damage. For example, and I use a light bulb example a lot. For example, failing to change a light bulb. Those are things that are fair wear and tear, things that get after a passage of time. Those are things that get faulty. But when you're talking about the exceptions would be if it is that they were flooding and they were damage caused as a result of flood. For example, structural damages as with the pillars or with the walls. The landlord cannot expect you to cover those kind of costs because those kind of costs are so absurd. It was not within the contemplation of the parties at the time. So when we talk fair wear and tear, we're talking about everyday costs. When we talk about the exception, we're talking about those that are not reasonably foreseeable. Um, and I use flooding, but we also have examples like hurricane. You have examples of probably bullet holes given the areas you are living in. But in a nutshell, it's really little markings. If you have carpet, little stains in the carpet. If you have dogs, for example, and you have the dogs shedding the hair, vacuum up the hair. If you have window panes and there's a little dust on the window panes or rusting or whatever, those kinds of stuff, or the paint is flaking out, nothing is wrong with passing a brush with it. There are reasons to differentiate what is accepted. You're really looking at reasonable deterioration that occurs over a passage of time that happens as a result of normal exigencies, sunlight, weather, those sort of things. But when you're looking at what is not considered, it would be things that are in the extreme, as well as things as a landlord side, for example, things that went bad as a result of misuse or negligence or intentional acts of the tenant. For example, there was a quarrel between, like, say, husband and wife is renting a property, and there was a big scuffle between husband and wife, domestic violence situation, and chairs started to fly and cause damage to the walls. Those are things that fair wear and tear will not exempt the tenant, and the tenant will have to pay the cost of those expenses.
Okay, perfect. Thank you so much for your information there. Now, folks, unfortunately, we have come to the end of today's episode now. This is an episode that we could have discussed for probably another half an hour again. And at this point, I really want to thank Mr. Aaron Mahabir for being with us today and sharing his wealth of knowledge on this very important topic. And we hope that as time continues, if we have other issues and questions of this nature to raise, that we look forward to having him return as a guest on our podcast. So, Aaron, on behalf of the Legal Corner podcast series, we want to thank you for your time and your wealth of knowledge, and just also putting our listeners in a position of knowledge so that as they continue to inhabit places, whether it is in by ownership or by lease or whatever the case is, that they have that added information. So again, on behalf of the Legal Corner podcast series, we want to thank you for your time and your information. And we look forward to having you a guest again in the very near future.
Quite welcome, Leonardo. It has been a pleasure. You were quite a good host, and I do look forward to coming back again to assist where necessary.
Thank you for listening to the Legal Corner podcast series. For more information, please visit us at our Facebook or Instagram pages or send your comments to thelegalcornerpodcast@gmail.com. We look forward to hearing from you.